Hello and welcome to this video lecture on fair dealing and the news media, which is part of Unit 7 of our program on media law. I'm Aju John and I will now discuss two situations where the news media needs to be aware of the principle of fair use as it is known in the United States or fair dealing as it is known in India. Now these principles began as judicially crafted exceptions to the rule of copyright. Now, the purpose behind the principle of fair use or fair dealing was to balance the rewards for the creator of a work with the need to widely disseminate information, knowledge and learning. Over the last 100 years, the principle of fair use or the principle of fair dealing has found its way into the statutory law of several jurisdictions. In India, it is found in section 52 clause 1 of the Copyright Act, which was amended as recently as 2012. Let us have a look at this provision. While the provision, notably, does not really define what fair dealing means, it clearly states that fair dealing with any work except a computer program for the following acts do not constitute copyright infringement. 1. Private or personal use including research. 2. Criticism or review, whether of that work or any other work. And 3. The reporting of current events and current affairs, including the reporting of a lecture delivered in public. So now we know the purposes towards which fair dealing with the work must be directed so as to not amount to copyright infringement. We may know this, but we still don't know what is meant by fair dealing with a work. Since the Indian statute does not help us understand what fair dealing means, Indian judges have relied on the English case of Hubbard versus Vosper, which contains Lord Denning's definition. Like many other judges after him, Lord Denning said that fair dealing is impossible to define. He said that one should consider the number and extent of the quotations and extracts from the work, then the use that is made of them, and then the proportion in which they have been used. While he mentions these three factors, he adds that after all is said and done, it must be a matter of impression. Now, relying on English and American authorities, Indian courts have looked at four factors to try and establish whether there has been fair dealing with a work. They are: 1. The amount and substantiality of the dealing. 2. The nature of the original work. 3. The purpose and character of the dealing, including the question of whether it is of a commercial nature. And 4. The effect of the dealing on the potential market for the work. Now let us look at these factors in greater detail. The first factor relates to the amount and substantiality of the portion used in relation to the work as a whole. The reasoning here is that the larger the portion used, the less fair the dealing. For the principle of fair dealing to apply, the portion used should not be too substantial. Secondly, courts are more likely to find that there was fair use if the original material was factually oriented. Facts and ideas, as we know from the reading material to this unit, are not protected by copyright. Only their specific expression is. The next factor relates to the purpose and character of the use. We've already seen under section 52 the list of purposes to which a work must be applied in order to qualify for the principle of fair dealing. In addition, this factor allows courts to look at the intention behind the use. American courts, for example, have looked at whether the subsequent work is transformative enough. A mere reproduction of the original work without any changes may not qualify for the principle of fair dealing. The likelihood of competition is the fourth factor. Courts will examine whether the subsequent work uses the same information contained in the prior work but for a rival purpose. If so, it will not qualify for the purpose of fair dealing. An interesting case that illustrates the use of these four factors is Supercassettes versus Hamar TV. In this case, the plaintiff alleged that Hamar TV had infringed their copyright in cinematograph works and musical works by broadcasting excerpts from these works without a license. Defending itself before the Delhi High Court, Hamar TV argued that the maximum duration of such a broadcast was only 40 seconds. That too, not at a single stretch. Also, its broadcasts were in the nature of review, preview, news, special programs, and interviews. The Delhi High Court's decision ultimately hinged on the use made of the works whose copyright infringement had been alleged, and on the duration for which the use was made. Thus, the court took both substantiality and purpose of use factors into account and held that Hamar TV's use of these works did not fall within the exceptions laid down in section 52. The court concluded by noting that repeated instances of infringement by the defendants would result in a reasonable cause for grant of aggravated damages at trial. Let us look at some typical situations that arise in the broadcast news media. While reporting a current event, for example, news editors and producers sometimes realize that vital footage that is required to report the event is protected by the copyright belonging to a rival news organization. Sometimes, even to establish historical context, these news producers and editors realize that vital archival footage is protected by the copyright belonging to a rival news organization. Therefore, in day-to-day life, these news editors and producers often have to make decisions about how they are going to use a rival news organization's video footage in such a manner that it qualifies for the principle of fair dealing. In 2008, the Delhi High Court in ESPN Star Sports vs. Global Broadcast News had to decide on a case where footage from cricket matches was used in news broadcasts. The plaintiff opposed the defense of fair dealing. ESPN Star argued that the extent of use of the footage and the fact that the news channel had benefited commercially from the use of the footage took away from their claim of fair dealing. Now, without making a decision, the Delhi High Court laid down various guidelines regarding the use of footage from protected works in news programs and stated that a news broadcaster would not be able to rely on the defense of fair dealing in case of extended use of footage of telecast beyond an acceptable period. This is quite like the substantiality test. So while we still do not know with any certainty when some kind of use by a news organization of video footage protected by copyright belonging to someone else qualifies for the exceptional circumstances outlined in section 52 of the Indian Copyright Statute, we know from the Delhi High Court's views that it is important that the use be for a bona fide purpose and insubstantial. Now, another circumstance where it is important for news organizations to understand the principle of fair dealing is in the context of aggregating on websites news from various sources. News aggregators, generally speaking, collect and present third-party content from traditional news and other websites. The largest such aggregator is probably Google News, which employs software known as crawlers to search the internet for content for news on a particular subject or from a particular source. Aggregators generally display the headline of a story. Sometimes it displays the first few lines also, and sometimes an accompanying photograph. The headline is usually linked to the original website where the story was first published. The problem arises because news agencies have claimed that their headlines and the few lines and photographs that appear on aggregator websites are protected by copyright. News aggregators have often claimed that even if they are protected by copyright, their use constitutes fair use, and moreover, that aggregation services benefit newspapers. So in this context of news aggregation, the most hotly debated of the four factors is the effect that aggregation has on the potential market for the original news article. The content creators, usually news agencies such as the Associated Press, would argue that there exists a well-defined market for reproduction and syndication of their articles, and the use by aggregators of those articles without paying a license fee directly threatens this market. In response, aggregators would normally argue that they in fact benefit news organizations by driving traffic to their website. They would also add that the kind of consumer who skims the headlines on an aggregation website is not the sort of consumer who would go to the original website and read the entire article. In 2013, a US federal court held that a media monitoring service had infringed the Associated Press's copyright by publishing excerpts of their articles. The defendant provided reports to its clients of news articles published on selected topics based on keywords selected by the client. The court held that Meltwater's use was commercial and not transformative, because Meltwater had republished significant portions of the AP articles in a service that competed with AP's original services. Now, this case from New York gives us a very good idea of how the principle of fair use is used in the context of the disputes between news organizations and news aggregators. This brings us to the end of this video lecture on how the principle of fair dealing is used in the context of the news media. Thank you for watching. Please attempt the practice exercises before you move on to the next unit.